how do we act to protect our clients' intellectual property rights outside of contract? The couple of issues there. Sometimes the type of contract requires the intellectual property rights to be assigned. That's just the structure of a songwriter agreement, or sometimes the structure of a recording agreement. They're gone, bye, so there is nothing to do about it. But in the early stages, the advice is often, look, register your songs. Don't freak out about it too early. Many clients believe that copyright registration is something that they must do to protect their rights. Really, copyright registration isn't the step that protects copyright. Copyright exists the minute a copyrightable work is created. Registration just gives the owner procedural rights against third parties. Good idea, but it's not like you can't function unless you register these copyrights. So that's a piece of advice. We'll say, you know what, register your copyrights, go to the Copyright Office website, do it yourself. You don't have to pay me to register your copyrights. Happy to do it, but it's easy to do, and I'll consult you. I'll tell you, if you have a question, it'll be a lot cheaper for you, for me to just answer a question or two, than for me to go through the whole process. Now, trademark registration of a name is more important. I encourage bands and artists, or record companies as well, to register their trademarks as soon as they can. That's something that's a little bit more technical, a little bit more complicated, so I generally do the trademark registrations, and that's totally separate and apart from a contract. It's just as you say, it's something that you need to do to protect your client's rights. And let me just say this generally about advising a client. And my role is, or my approach is, I will advise my client of all the things that they need to do from the most conservative position to protect their rights. They then have to prioritize what they can and cannot afford to do or don't feel like doing at this point. I might say, here's 5 things. Here's step 1, 2, 3, 4, 5. Trademark registration is one of them. A band agreement is another one. They may say, you know what, we can do the trademark agreement right now, but we're going to have to cross our fingers and not do the band agreement right now because we can't do it. But at least it's on the list, and they'll hopefully get to it later on. I have a very experienced entertainment litigator, great trial work attorney. He's the guy that I send those, if a project comes to me that already involves a dispute, then I don't do it. Particularly if I wasn't involved in the project in the first place, somebody contacts me and says, I've got a copyright infringement claim, I think. Somebody stole my song, and I don't know them. I'm going to say, you know what? This is the guy you need to speak to. Now, if it's my client, then I'm still going to say this is the guy you need to speak to. Because, again, it's a different area of expertise. Going to court is completely different than drafting a contract. My litigator's not really going to be drafting contracts generally, and I'm not going to be going to court. We will work together, and I will say, I'm going to be involved in that project, again, especially if I have a relationship with the client. But I'm not the guy that goes to court, and frankly, it's dangerous, in my view, to have somebody, again, it's like if somebody comes to me and says, I want to purchase a $5 million building, and I go, I can probably do that. I think that's dangerous. Just as it would be dangerous to go to a real estate attorney with a management agreement. There is experience that you get over time that applies to the subject matter of your work. And that divide occurs right in the entertainment business between transaction and litigation as well. Documents have to be filed in court. I don't know what document needs to be filed when. That's a very specialized area, and you need someone who knows that area to be advising you on it.